Well, good afternoon, everyone. Thank you for joining us this afternoon for our August 15th SPED LEA TEA webinar. We've got one agenda item this afternoon for you, but I did want to give a few reminders. One of them is we are recording this, and within a few days it will be posted to the webinar site. Also, the chat feature is disabled, but the Q&A feature is. So please type in questions. That really helps us with any future clarification that might be needed in a webinar or the guidance documents that we provide. We won't be answering them directly, but it really helps us whenever we need to provide some clarification on documents or for the guidance documents. So continue to send in those questions. We appreciate it. So I'm going to start by sharing my screen and then showing you a little bit, or just kind of reminding everyone about the webinar site, because that's where today's document is housed. Let's share this one. All right. Stephanie Koch, give me a thumbs up if you can see our special ed site. Awesome. Okay, so those of you who are familiar with our webinars know that when you come to the special education website, and hopefully you've got that saved as one of your favorites, but oftentimes you will scroll down to the webinar and newsletters tab. We also want to encourage, if you haven't signed up for updates, a lot of information that we send out comes to people that have signed up for the updates. So be sure and take some time to do that if you haven't already. But under the webinars and newsletters, the newsletters are archived, and then the webinars are always going to be here. So today we have Kristen McGuire with us, and she's going to talk about the back to school updates for special educators. So take a little moment right now and make sure that you've had the opportunity to click that, because that's the document that she's going to be talking about today. And then just a reminder, you can see where you view webinars once we have the recordings. So we're recording this, and within a few days it'll say view if you want to go back and view this webinar. So I'm going to stop share and then hand it over to you, Kristen.
All right. Let me get mine up. And hopefully you see mine. All right. My name is Kristen McGuire. I am the Deputy Associate Commissioner over Special Populations Policy, Integration, and Technical Assistance. We were asked, we have a lot of administrative code, commissioner rule changes, and State Board of Education rules through the administrative code that have changed recently. And so wanted to just offer another opportunity to kind of hear about those changes. We did send this, as Anna showed you, there's this document is linked in on that webinar page, so you have it. But we did want to talk through a few of some substantive changes that were effective on July 30th. I do want to also point out before we get started going through this, is that we do expect another round of commissioner rule changes to be effective on the 22nd of August. And so we'll be obviously back to talk through some of those changes. So, obviously here at the agency, there's always, and within the field, there's pros and cons of trying to do, a lot of rule cleanup and some changes, pros and cons of whether to try to do it at once or whether to spread it out. And so we went with the approach of trying to clean up some rules in a pretty short window of time. So hopefully we'll be set here in a month or so with rule changes, of course, until the legislative session starts, and then we'll see what rule changes we make from there. But that said, just wanted to let you know there are some other rule changes coming up. We'll of course be back to talk through those. But in terms of this particular document, we wanted to walk through several of the rule changes. On this document, of course, the rules themselves are linked so that you can click on those and review them. But when you are The first rule in 19 TAC 89, 10, 11 is about the initial special education evaluations. And so one of the changes there is that when a district is essentially responding to a request for an initial evaluation, one of the sort of new requirements to give parents is that overview of special education for parents form. Many of you are familiar with that form already because that was created actually in response to House Bill 3928 from the 88th session about, and that was specifically for suspicions of dyslexia. What we've done in this rule is we have made that form a requirement for all disabilities, so all suspicions of disabilities. So when you are giving out your prior written notice and procedural safeguards and opportunity to provide consent or that refusal to conduct an evaluation, you are giving parents that overview form. In terms of initial evaluation timelines, oops, let me go back. So there is a new requirement in 89, 10, 11 that does require a copy of the written evaluation report to be given to parents, obviously as soon as possible after the completion of the report, but no later than 5 school days before the initial ARD committee meeting. So that is a new requirement, and so make sure that that your staff are familiar with that particular requirement. In previous rule, we had a statement that essentially said, so obviously we have our timelines for our evaluation, our 45 school days, with those certain exceptions for student absences or, the length of time before the end of the school year. So we have our kind of established length of time for evaluations. Then, of course, from there, we have 30 calendar days to hold an initial ARD committee meeting to determine eligibility. In previous rule, it did say that if the 30th calendar day fell during the summer, that the initial ARD committee meeting needed to be held by the first day of school. That has changed in the rule to allow for up to 15 school days. Now, of course, we'd always, want you to do it as soon as possible, but in terms of compliance and the requirement, there is 15 school days. That was done, primarily because we have a 5 school day notice before, before an ARD committee, and you can't quite give a school day notice if you're not in school in the summer. So that has changed from the first day of school to the 15th school day. So moving on to IEPs, your individualized education programs. So in 19 TAC 89, 1055, which talks about your IEPs, there are some new provisions in that rule about essentially what makes a measurable annual IEP goal. And so what is in that rule is consistent with guidance that we have put out for several years, but it seemed appropriate to go ahead and put that into the rule standard for IEPs to ensure that everyone knows kind of the expected compliance for those measurable IEP goals. So there is a statement in there, of course, that while the ARD committee will determine the number of annual goals for a student, there are a couple of times when they're required, absolutely required. It's, of course, if the content of the subject course is modified, you need to have an annual IEP goal addressing that modification. And then if a student is removed from the general education setting for a scheduled period of time, but the content of the subject course isn't modified. So if you have a student in that situation, sometimes you see that with a student who might have challenging behaviors that is removed from that setting, but they are being removed from general education for a period of time. And obviously there needs to be a particular goal and an IEP goal for addressing that particular need. Short-term objectives and benchmarks. So those are always kind of optional in general in terms of a measurable annual goal, but they have to be included for a student who has been determined eligible to participate in the alternate assessment. So the STAR alternate 2. So when a student is determined to be eligible for that STAR alternate 2, there does have to be short-term objectives and benchmarks. However, you can't use those objectives and benchmarks to be sort of your full criterion in indicating mastery of that goal. Within the IEP, if a student has been determined to be eligible for the STAR alternate 2, there is an agency participation form that our assessment division has put out. And so if the student meets that eligibility, that form needs to go ahead and be included into the IEP so that reflects the sort of required statements that are required under federal law about why the student can't participate in the regular assessment. So next up in the IEP is no later than the first IEP to be in effect when the student turns 14. The ARD committee must consider and address all of the required transition issues or transition topics that are in that rule, of course, which are also in federal regulations as well as state law. So there, in previous rule, there is some state law that requires some transition to be effective at 14. And there are federal regulations that require certain post-secondary goals to be required at age 16. What this new rule does is brings both of those back down to 14. We will, they sort of intermingled anyway. And so essentially the states decided to sort of move those federal requirements that they require at 16, we've moved those down to 14. And then also within that rule, within your IEP, you have, so for several years, we've had kind of some back and forth with students who withdraw from one district and register into a new district in the summer. If these students were students who, had IEPs in effect in the previous district, there were kind of varying processes to kind of get a student sort of started into the new district. And so part of the sort of variations that's happened across the last few years with this particular topic is that the federal regulations and guidance don't really talk. Doesn't really mention students that register in the summer. It really focuses on like what they call school year transfers. So if they register from an in-state district or an out-of-state district during the school year. So there wasn't really much guidance at all associated with those who register in the summer. And so absent guidance, for quite a few years now has been essentially the premise of, well, I guess we rely on the fact that, IEPs need to be in effect the first day of school year, right? Well, there has been some guidance within the last couple of years where the Department of Education has essentially kind of lumped these summer registrants into kind of that category of school year transfers. So all that said, it's kind of this nuanced process for those who register in the summer isn't really a nuanced process anymore. We essentially consider those who register in the summer the same as we would as school year transfers. So really what matters in terms of how to get that student started in your district is whether they are an in-state or out-of-state transfer student. So you'll want to just review that particular rule to make sure that you kind of understand the requirements of that, but no longer, you know, real a specific difference for those summer registrants. And then we did have in 19 TAC 89-1065, which is about extended school year services. There are some additional revisions into that rule, but what it did just essentially kind of clarify is that in your annual ARD committee review or your IEP review meetings, that it is required that ESY be discussed. And then, of course, if the student is determined not to be eligible for ESY in an annual ARD meeting, you know, obviously if data supports eligibility later on through that school year, that there would be a meeting or an amendment to discuss that. So in prior rule, it just essentially said, if it's not discussed, then a parent can ask for it to be discussed. So this is just some clarifying language that, yes, the expectation is that it will be discussed. All right. So then we have quite a bit of changes in our eligibility rule in 89-1040. There are some substantive changes, some are clarifying changes. So you know, I'll kind of you know, signal to you whether something is, you know, obviously a real substantive change. Under autism, this really isn't a substantive change. It was more just clarification that we've always operated under, but there was a request during public comment to make sure, you know, that districts are aware that the, you know, kind of the medical diagnosis for autism is different. So you cannot require a medical diagnosis when you are considering eligibility for autism under IDEA. Also, in the federal regulations that describe autism eligibility, it does mention some characteristics, some other characteristics that are often associated with autism. And the clarification made in the rule is that, you know, if the student doesn't exhibit those kind of quote unquote other characteristics, that doesn't automatically exclude them from eligibility under autism either. So, you know, again, those are just in the federal regulations as, you know, kind of examples of behaviors that students or children with autism may have, but it is not kind of an exclusive or mandatory list. The deaf or hard of hearing eligibility was updated to no longer require an audiological evaluation or examination to determine eligibility. And this was based on a petition for rulemaking that was made, gosh, it's probably been almost 2 years ago now, or a year and a half ago at least. And so that requirement, once it was put out, you know, for stakeholder kind of opinion, that petition was granted in the form of this rule change. So students to meet eligibility for deaf and hard of hearing do not have to have the audiological eval. So this is this will be a substantive change. And so traditionally, Texas has not utilized the eligibility category of developmental delay, which is allowed under the federal regulations. So the federal regulations allow states to create a definition of developmental delay and use that as an eligibility category for students receiving special education services. Now, within those federal regulations, it says, you know, obviously the state develops a definition. Districts do not have to use this category of developmental delay, but if they use it, they have to comply, obviously, with the state's definition. So Texas has not traditionally or historically had this eligibility category. We've used instead kind of a non-categorical non-categorical early childhood designation, which was, ages 3 through 5. And so our current non-categorical early childhood definition requires the child between 3 and 5 to have been identified with a certain disability under those eligible disabilities. But essentially due to their young age, that category or eligibility criteria category didn't want, the ARD committee decided not to use that. So they used NCEC. And that was allowed through the age of 5. So there must, be a reevaluation before age 6. What we are transitioning to in the next couple of years is to go ahead and use the term and the eligibility developmental delay. So in the rule at 89-1040, there is a definition of developmental delay. And there is some kind of, transition provisions, basically. So, school districts may use the eligibility category of developmental delay this school year. They are allowed. They don't have to by any means. Starting with the 25-26 school year, we will no longer be using non-categorical early childhood. However, there's a caveat to that if a student starts that year already, so let's say they're 4 or even 5, and they had already been identified as NCEC, they can continue with that eligibility again until or through through 5 when that reevaluation at 6 would have otherwise been required. So we're just not identifying any new students as NCEC beginning in 25-26. Now, of course, for us here at the agency, we will be obviously working on a lot of appropriate technical assistance moving forward to that transition to help out the field with questions that they may have. The other kind of big change as opposed to NCEC is that based on substantial public comment that we got when this rule was proposed, the request was to allow this eligibility category up through age 9, which is allowed under the federal regulations. Initially, we had proposed it to stay kind of that same age range of 3 through 5, but based on a lot of public comment, the request was to change that to 9 to match the federal regulations, and that was done at adoption. So that will be allowed through age 9. The deaf and hard of hearing and visual impairment, there are also some new kind of eligibility criteria for your students under 3. So under state law, babies from 0 through 2 years of age who have a visual impairment, who are deaf or hard of hearing or deaf blind, do have access to state funds and to special education services. And so what we were kind of missing in that particular rule was matching some of the idea C, which is your early childhood kind of rules associated with disability criteria rather than school age. So you'll see some additions there. In the federal regulations under eligibility criteria, there is a category, of course, called emotional disturbance. We've actually been asked for several years, and of course we, most of us, here in the area of special education here at the agency have worked in the field and have had the same kind of feelings about that particular term. So the federal term uses emotional disturbance. We have changed through our rulemaking that the term of eligibility will now just be emotional disability. The criteria, of course, has not changed. There is, essentially a statement that, when we use the term emotional disability, it means emotional disturbance under the federal law. But in terms of, how we want to refer to this disability, it will now start being referred to as emotional disability. Orthopedic impairment and traumatic brain injury, more of a clarifying change. In previous rule, it was kind of talking about the physician being part of the multidisciplinary team. Obviously, what's key here is more of the supportive medical diagnosis for the MDT to consider, so that changes were made there. Same kind of change under other health impairment. That not necessarily a formal member of the MDT, but what's important is confirmation of the student's health condition for the MDT when they're determining evaluation. All right, so specific learning disability. We'll talk a little bit about some changes in relation to specifically to dyslexia here in another page. But within this section is just a reminder, several years ago, the kind of significant discrepancy model was repealed through our rule. So this is just a reminder that, again, a significant variance between or among specific areas of cognitive function or academic achievement are not required for SLD eligibility. Whew, talking a lot, but I'm gonna get through this. Let me take a sip real quick. All right, so with let me make sure I didn't miss anything. Okay. So talking specifically about some dyslexia or dysgraphia requirements. So what we've had also with some changes in commissioner rules is, of course, we have had the State Board of Education has revised their rule associated with dyslexia and related disorders, which is at 19 Tech 74.28. Now that rule incorporates the SBOE's dyslexia handbook within that rule. So all that to mean that the rule and the handbook are both required because they are part of the State Board of Education's rulemaking authority. So that rule and the handbook were effective June 30th of 2024. And so what some commissioner rule changes have also adjusted essentially to those requirements. So again, just a note, you already know this, that each school district and charter schools boards need to adopt a policy about complying with the SBOE's dyslexia program and procedures, which is inclusive of the dyslexia handbook. There is a change in the rule itself at 74.28 about in previous rule, it referred to a parent education program that was specifically sort of targeting parents of students who had already been identified, with dyslexia. The change in the rule is to provide information to all parents about essentially dyslexia and related disorders. So you can see kind of the checklist there of what that information must include. We are actually currently working on kind of a sample information sheet that districts could choose from or choose to use for that information. But in terms of the rule itself, there's no required way to distribute the information. It just has the list of what's required. All right, so within the handbook itself, the universal screeners for dyslexia, of course, they are still required in kindergarten and in grade 1. So kindergarten is at the end of the year. First grade is still required by January 31st. The only kind of slight tweak by the SBOE was made to just say that the screener for grade 1 should be as close to the middle of the school year as possible, but no later than January 31st. So one of the key pieces to remember from the statute, as well as what is now clarified in the handbook, is that when dyslexia is a suspected disability, the MDT, which is that multidisciplinary evaluation team, the team that's responsible for the comprehensive evaluation, must include a member who has specific knowledge of the reading process, dyslexia and related disorders, and dyslexia instruction. And so the statute, excuse me, requires that this member be either a licensed dyslexia therapist or someone who has the most advanced dyslexia related certification. And what the SBOE has done through their handbook is they were charged in the statute to essentially define, what does that mean? What does someone with the most advanced dyslexia related certification mean? So they have outlined that through what you see here at the second and third bullets. So must be one of those. So must be a LDT or someone with the most advanced dyslexia related certification. And only if those individuals are not available, then you can designate, someone else to serve in that role. And so in order to designate someone to serve in that role when those first two are not available, that's part of what the SBOE did as well, is to decide what are the training requirements for this person. So their requirements are that the person register and complete the Texas Dyslexia Academies, which are offered by TEA. We are almost done, just by the way, with posting those. So those will be available asynchronously through TEA Learn for free, as well as still being available synchronously through education service centers. So those will, so those are part of the training. Second part is register and complete TEA's guidance for the comprehensive evaluation of an SLD. There is an existing technical assistance guide that is getting updated because of rule changes too, but there is an existing technical assistance guide. This is a course essentially that corresponds to that guide. And then last would be to document that the individual has training in the current research and evidence-based assessments that can identify dyslexia. So again, kind of you have the two required kind of options, and only if they are not available may you choose from that third option, and that person would then be required to take the training. So identification of dyslexia and dysgraphia must include, obviously, an evaluation that addresses all of the domains and requirements that are in the dyslexia handbook and in the rule. And then when you are obviously writing the evaluation report and developing an IEP, that the terms, if dyslexia or dysgraphia is identified, obviously using those terms in those reports and in the IEP. All right, so then when considering initial or continued eligibility for special education for dyslexia, the ARD committee must include that same member that we just talked about. So the LDT or the most advanced dyslexia related certification, or if they are not available, then that third person with the training. So if an ARD committee determines the student has dyslexia, which of course, again, as a reminder, that is a disability under IDEA as an SLD, the ARD committee will determine whether the student requires the provision of special education related services. So if the student is determined to require dyslexia instruction, then that means the student meets eligibility for special education and related services, because dyslexia instruction is considered specially designed instruction. So then those IEPs would then of course be developed and implemented, again in accordance with 74.28, which is the SBOE rule and the handbook. All right, and then lastly, the last kind of update is just to make you aware in terms of the Supplemental Special Education Services Program, SSES. The agency has sort of transitioned just operationally in how we refer to that program. So we're referring to it as parent-directed special education services, just to sort of emphasize again more of that this is more of a parent-directed and not a kind of school-directed special ed service. So it's a parent-directed special education services program. And the eligibility hasn't changed, anything like that, but we have instituted an application window, and that helps for a variety of reasons, obviously, is, one of which is to prioritize students that we are required to prioritize under the statute, as well as not continue to have kind of these kind of ongoing waiting lists that sometimes get funded at kind of odd times. So this is a program, obviously, that is still subject to appropriation by the legislature. So if there is more demand than we have money appropriated, then obviously we can only give out as much as we were appropriated. But that said, the application window will kind of give us a better idea of what that looks like. So next application window will be open on February 3rd of 2025. And as far as what kind of a school district's responsibility will be is, unless a school district's already aware that a parent has already applied or received a grant under this program, an ARD committee will still need to let parents know about essentially how to apply and what the program is and kind of what are some of the goods and services that are allowed to be purchased. If they know the parents already applied and or received, then there is no additional ARD committee responsibility. So I have said that very quickly, but that essentially is the gist of our back to school update document. As I mentioned at the beginning, if you joined us a little bit late, we do expect an additional kind of set of commissioner rules to be posted in the Texas Register tomorrow with an effective date of the 22nd of August. Obviously, no guarantees until I see it in the Register, but we will continue to keep you updated of those particular rule revisions. Those rule revisions are primarily about our instructional arrangement rules, as well as our non-public day and residential placement rules. We do have a few rules still out for public comment right now. So those will be finalized here in the next few months. Again, I also want to mention that under the dyslexia webpage, you can just go to tea.texas.gov/dyslexia. The dyslexia handbook link has been updated to also include the handbook FAQ that we just posted on Friday. So if you click on the PDF of the handbook itself, you'll see the FAQ embedded into that PDF. Also on that page is the link to the FAQ just by themselves. So, please make sure and go review those as a resource in implementing the requirements of the SBOE's dyslexia handbook, and continue to send us questions, or those of you who are in school districts and charter schools, if you want to send questions through your ESC representatives, that's perfectly appropriate as well. We also have our general SPED email box at sped@tea.texas.gov. So appreciate you guys joining. Anna, anything else we need to say before we wrap up?
I don't think so. I know that a few questions have come in, so thank you for those questions. And knowing that we're going to come back at a time follow-up, Kristen, on the 22nd or shortly thereafter, maybe we can kind of update on any of the questions at that time. I do see a few people who have raised their hands, so I just encourage you to ask those questions because there's not an interaction on this particular webinar. So I'm going to stop the recording, but I'm going to leave. Just going to sit here for a few minutes in case if you want people want to type a few more questions, and then I'll close it out. But Kristen, thank you so much for being with us and sharing the information. It's a lot. You got through a lot and only had to take a couple sips of water.
Right,
so.
right.
Thank
Yes,
you so
absolutely.
much.
My pleasure.
Yeah.
All right.